Good morning from the Oklahoma Insurance Department. My name is Rachel Fan, and I work in the Communications Division here at OID. Thank you for joining us for our Medicare Mondays webinar series. For your awareness, I do want to mention that this webinar is being recorded. Before we get started, I wanted to share a bit about what the Oklahoma Insurance Department, or OID, does. OID is a state agency, and we are responsible for regulating the insurance market and enforcing the insurance-related laws of the state. We have an entire team devoted to protecting consumers by providing them with accurate information and timely assistance. We can also deal with your insurance company if you can't reach an agreement regarding a claim. If you would like to reach out to us for help, or if you have any questions, you can call us toll-free at 1-800-522-0071. And you can also visit our website at oid.ok.gov. For today's webinar, you will be able to see and hear us. However, we cannot see or hear you. If you have a question, please type it in the chat. At the bottom of your screen, you will see several options, one of those being chat. And if you click on that, you can type your questions there. We will save time to answer questions at the end of the webinar. Now I'd like to introduce our speaker, Juli Cowden. Juli is the coordinator of volunteers for the Medicare Assistance Program at the Oklahoma Insurance Department and has been in this role for a little over a year. She has worked in public health and around the medical field for 15 years. Helping beneficiaries navigate Medicare and learn how it works for them makes her position very rewarding. Juli, over to you.
Thank you so much, Rachel. And welcome everyone again to the Medicare Mondays. First, we want to just tell you a little bit about our program. We are grant funded from the Administration for Community Living to provide education and assistance on Medicare-related issues, and not just to beneficiaries, but also families and caregivers. We partner with agencies around the state to provide these services across Oklahoma. So today we are going to talk a little about Medicare appeals. A few of the things you can appeal are listed below. Now, of course, this list is not exhaustive, and anytime you see that Medicare or your plan has denied something, you may appeal that action. Every Medicare summary notice, if you have original Medicare, and Part D plan explanation of benefits includes instructions on how to file an appeal. The sample seen here is the sample you would see with a Part B original Medicare denied claim. Advantage plans should provide a notice of denial of medical coverage if they will not cover a requested service. If the service has already been provided, you may see the denial on your explanation of benefits or a notice of denial of payment. Both documents will include the instructions for appeal. You must ask for an exception to start the appeals process for Part D. Now, this could be either a formulary exception if a required medication is not on the plan's formulary, or a tiering exception if the medication is in a higher priced tier and lower priced medications are ineffective. If the exception request is denied, instructions for beginning the appeal process will be on the notification. There are 5 levels of appeal for Medicare. This chart is an overview of those levels, and we'll look a little closer at each level. Level 1 appeals are when you follow the instructions listed on the documents from Medicare or your plan telling you a service, procedure, or claim is denied. For Part D, if your pharmacist tells you that your plan will not pay for a prescription drug, they should provide the notice titled Medicare Prescription Drug Coverage and Your Rights. Once you know why your drug is not covered, whether it be due to non-formulary or coverage restrictions, you can speak to your provider to see if a drug that is on the formulary is comparable. And if not, you can begin that appeal process. The Medicare Model Coverage Determination Request is used with Part D appeals. It is a form that asks for the type of coverage determination you're seeking. One of those options We have the non-formulary and we have the tiering exception. Another option is reimbursement if you've already paid for a covered prescription drug out of pocket. At level 2, the QIC, or Qualified Independent Contractor, is retained by CMS and conducts the appeal for Original Medicare. For Advantage plans, the appeal is automatically forwarded to the independent review entity if the response deadline for one isn't met, or if the level 1 decision is not in your favor. For Part D appeals, level 2 are not automatically sent, so you must follow the instructions on your level 1 appeal decision document. When filing appeals, it's very important that you keep everything you submit, keep a copy of that. Very, very important at every level to keep copies. Now, levels 3 through 5 are the same regardless of whether it's Original Medicare, Medicare Advantage, or a Part D drug plan. Each of these levels are the same. Now at level 3, an adjudicator will determine if the case is valid and may issue a judgment based on the record. A beneficiary may also submit a form titled Waiver of Right to an administrative law judge hearing if they don't want a hearing, but do want the case decided by the adjudicator with a review of the administrative record. Now, if you do prefer and request a hearing, hearings are held by telephone unless the administrative law judge finds good cause for an appearance by other means. And this could be a video teleconference or even in person. CMS or its contractors, for instance, the Qualified Independent Contractor from the Level 2 appeal, may participate in an administrative law judge hearing after they notify all of the parties to the hearing. Another thing with level 3 is the introduction of the amount in controversy. When you get to level 3, you must meet the amount in controversy threshold to continue on the appeal path. This amount is $180 for 2024 and is adjusted each year. In our example, we see a Part B claim of $1,000. Medicare has paid nothing toward the claim. And if a person has met their Part B deductible, making them responsible for 20% of the entire claim, then that means they need to pay $200, leaving a balance of $800. So the amount in controversy is the total claim minus anything Medicare has paid or the plan has paid, minus anything the beneficiary has paid or should pay, such as a deductible, coinsurance, copay. The remainder is that amount in controversy. So in our example with the deductible met, we see $800 remaining. If, for instance, this person still owed their full $240 Part B deductible, then that would subtract $440 from the $1,000 total, leaving us with $560, and that still meets the amount in controversy. So this example would be allowed to continue at the level 3 level. Now, if the level 3 appeal is not favorable, then you can move to level 4. Now follow the directions in the hearing decision from level 3 and include a copy of the administrative law judge decision with your level 4 appeal. Please make sure at each step you follow the instructions that are given on requesting the next level of appeal. So what can the Medicare Appeals Council do? Well, they may change the parts of the level 3 decision that you agree with. They may adopt, change, or reverse the level 3 decision in whole or in part. They may send it back to an administrative law judge for further action, or they may dismiss the appeal. Now, the council will limit its review to the issues raised in the appeal unless the appeal is filed by an unrepresented beneficiary. In that case, they will consider the entire record. Level 5, you may want your doctor to help with this level, or another prescriber, or your prescription drug appeals. They can request this on your behalf. And if you want them to, you need to submit an appointment for representative form. That form specifically authorizes someone you choose to be your representative for appeals. And the form must be signed by both the beneficiary and the person chosen as a representative. As with any CMS form, detailed instructions for completion are available online along with the form. Now here you see we are dealing with the amount in controversy once more. However, it's considerably higher. So in our previous example, it would not be able to move forward to this level 5 appeal simply because this $1,840 amount in controversy threshold has not been met. Excuse me. Now, as with anything, when you're appealing, there are timelines that must be adhered to. So with original Medicare, there will be a date on the back page of your summary notice, and it will tell you your appeal must be submitted by that date. Now you can request expedited review by submission to the Qualified Quality Improvement Organization, which is KeyPro for our area, and no later than noon of the calendar day following receipt, that service will be terminated. With Medicare Advantage, within 60 days of that initial decision notification, also called an organization determination, and then for Part D plans, 60 days from the initial decision notification. For Level 2 appeals with original Medicare, within 180 days of receipt of your redetermination notice. With Medicare Advantage, remember, it's automatically sent to Level 2 if the Level 1 decision is unfavorable to the beneficiary. And for Part D plans, again, 60 days from redetermination decision date. As discussed earlier, we saw that appeals for levels 3 through 5 are the same regardless of plan, and that timeline is 60 days after receiving the unfavorable notice from the previous appeal level. And remember, for levels 3 and level 5, you must meet the amount in controversy threshold, or you cannot appeal beyond. Now, if you miss an appeal timeline due to any of the reasons listed here, you can request what's called a good cause extension. To request this extension, include the appropriate information with your appeal request, as though you're submitting a regular appeal. Explain the situation fully and why you were unable to file timely. If the appeals reviewer approves your request for an extension, you'll get a decision within 60 to 90 days, depending on the level of appeal. If your extension request is not approved, your appeal will be dismissed. And information on how to appeal a dismissal is included in that dismissal letter. And these extension requests are considered on a case-by-case basis. Expedited appeals or expedited reviews for original Medicare, if you're in any facility of the types listed here, you can request an expedited appeal if you feel you are not ready for discharge or the service is terminating. A reduction of service can only trigger an expedited review in the case of skilled nursing, when reduction of care from daily to intermittent will mean the beneficiary is no longer eligible for Part A coverage. Otherwise, a reduction of services does not qualify for an expedited appeal. You should receive a document titled An Important Message from Medicare that you must sign within 2 days of being admitted as an inpatient. You'll also receive another copy of this document before you're discharged. The document explains your rights as a patient and contains contact information for the Quality Improvement Organization, or KeyPro. Please make sure you or your representative read it carefully. For Medicare Advantage plans, you or your physician can request an expedited appeal if the standard time frame will jeopardize your health, your life, or your ability to regain maximum function. These Advantage Plan expedited appeals typically occur when prior authorization is being sought for a service, procedure, or test. And if you are already in one of these listed types of facilities, you may request an immediate review by the Quality Improvement Organization KeyPro. Now, while an expedited appeal is being reviewed by the QIO, you may be able to stay in the hospital. They can't force you to leave before a decision is reached. Just bear in mind that while you're there, all coinsurance, copays, and deductibles may still apply. And this applies if you are appealing an expedited appeal through original Medicare as well. For Part D plan expedited appeals, remember, you must file an exception request to start the appeal process. And that applies whether it's a standard or expedited appeal. Now look here at the difference in timeframes regarding whether or not you have doctor's support of the expedited appeal. Because without that supporting statement from your doctor, the plan has the standard 60 days to make a decision on this appeal. The 72-hour expedited appeal will only apply if you have a supporting statement from your doctor. Now, additional resources through CMS.gov, Medicare.gov, and MedicareInteractive.gov. You can search appeals at any of these sites and find some really good information. CMS.gov, searching appeals there, will get you to any of the forms needed to progress in the appeal process or to appoint a representative. Medicare.gov will give you a good look at timelines for filing appeals. And Medicare Interactive just is another third-party site that can give you some really beneficial information on Medicare appeals. Please don't forget to contact your nearest partner agency for local help with Medicare. There are trained counselors in all of these locations. And don't forget the remaining Medicare Mondays for this year. There are some changes coming down in 2025 that you want to make sure you know about. Okay, Rachel, did we get any questions today?
No, Julie, we haven't had any questions in the chat, but just a friendly reminder, if you do think of a question after the webinar, you're always welcome to reach out to us via email, and we're happy to help you there.
Absolutely. Thank you so much.